Hi, all. We'll start. We're letting a few people join us. So we'll start in 1 minute. All right, let's get started. Thanks for joining me for the second of my 10-part series, my Arbitration Boot Camp series. And thanks for the feedback. For those of you who attended my first session, I did get your feedback. And some of you have suggested some future topics for me to cover in future sessions. I've made a note of those and I will address those. Just as the last session, I'll do about a 45-minute talk and then leave about 15 minutes open for Q&A, although I do have my Q&A box open. So if you've got questions while I make my presentation, feel free to ask them. And if I miss any along the way, I'll try to catch them at the end. And I guess the last important issue for you to know is that I did receive accreditation for 1 hour of professionalism credits for this seminar. So just a few introductions before we start. Who am I? I'm a partner at Lerners and I'm an arbitrator at Arbitration Place. And as I said in the last session, I conceived of this session in this series because when I had a counsel practice and was doing commercial litigation matters, there was no one place I could go to get kind of the fundamentals in arbitration very quickly. I think there's an assumption that we know a lot of the basics, and having the foundation is really helpful when you're reading the case law, reading the legislation, and that sort of thing. And so this boot camp was conceived in the hopes that I could kind of give everybody a primer. And for those of you who already have some experience, hopefully you can learn something as well. And in particular, hopefully you'll find some of the resources that I'm going to circulate at the end of the session to everybody. So you've got actual precedents and resources that you can use in your own practices and take some of the conceptual stuff that I refer to today into the practical. So let's talk about what, just give you an overview of what my session is going to cover today. So I've called this best practices for our arbitrator interviews, but it really covers all of the communications that take place between counsel, usually not parties, usually counsel and the arbitrator from the very first contact throughout the arbitration through to the end of the hearing and the issuance of the final award, because it's very important that those communications be managed in order to not jeopardize the process or the arbitrator's independence and impartiality. The first contact with the arbitrator in particular has lots of risks, which I'm going to describe today. And I know a lot of counsel don't think about that, because I often get calls out of the blue where somebody just phones me up and says, hey, I'm looking for an arbitrator to deal with X and Y, and the person gives me a summary of the case and a few comments about the various legal positions. And if those calls were directed to get information from me, great. But if they're a call to see if I'd be interested in taking on the arbitration as arbitrator, there's a risk that the line has already been crossed and has put me in a position where there could be a challenge to my independence and impartiality simply by that casual conversation. So I wanted to set out in this session the best way to make that first contact and then any future contacts. And that's what this is about. What information should you provide to the arbitrator in order to do the usual conflict searches, but also what information do you want from the candidate that you're considering in order to make a decision about whether you'd like to actually engage that person. Obviously, that's going to require some communication, but it needs to be managed in order to ensure the integrity of the process. So the topics I'm going to cover today are the ethical duties of the arbitrator, which I've referred to as already, the requirement to be independent and impartial. And that applies not only to a sole arbitrator, but also to a party nominated arbitrator. So a party nominated arbitrator on a panel of 3, and the party nominating the arbitrator cannot believe that that arbitrator will show that party any special consideration. All 3 members of the tribunal must be impartial. I'll talk about the dangers of ex parte communications, and as I said, even before the arbitrator is appointed, pitfalls in pre-appointment communications, starting with that first contact, and how an arbitrator protects the integrity of the arbitration. And this is important because ensuring that communications are managed avoids challenges later on to the arbitrator for lack of independence or impartiality. And this can take place anywhere along the arbitration, from early stages through to the end, and even following the issuance of the award. There are circumstances in which there have been challenges after the award has been issued, and you can imagine the cost and inefficiencies that are associated with those kinds of challenges. So part of the duty of the arbitrator is try to minimize the possibility that that will happen. So the ethical duties of the arbitrator: independence and impartiality, as I've already said, and those are found in the legislation, the relevant legislation, and the rules. Independence refers to the arbitrator's relationship to parties, to the issues, to counsel, and impartiality refers to the actions of the arbitrator, treating the parties equally. And before an arbitrator takes an appointment, and before there's a possible interview, which is the main subject of this talk today, that it's necessary to do a conflict search in order to make sure that there are no issues that can be identified out front, which could give rise to potential challenges. And when arbitrators are appointed, they often have to actually assert in statements that there are no potential conflict issues. And it's good practice for arbitrators to do that, whether the institution requires it or not. So what often happens is, if there's a requirement that the arbitrator disclose issues that may give rise to a reasonable apprehension of bias, that's one of the tests, or justifiable doubts as to the arbitrator's independence or impartiality, that's another test, that those items be disclosed to the parties, who may then waive them or not. And those obligations occur throughout the proceeding. And if there are no such issues to disclose, it's good practice for arbitrators to say that there are no such issues. So where do you find information about these obligations so that both parties, their counsel, and arbitrators can be assured that they're considering the right issues, making the right inquiries, and disclosing the right right issues? The Law Society of Ontario rules of professional conduct are helpful in talking about conflicts of interest, but they're really focused on the work that counsel do advising clients. And so a much more useful resource is one that is directed specifically to the arbitration context. And so you'll see in the legislation, as I said, the tests. the Ontario Arbitration Act, the Untitled Model Law, they contain certain kinds of tests. And there is a resource which will be the subject of the session in December, which talks about the analysis that an arbitrator should do to determine conflicts, and how to do that kind of analysis. So I'm not going to focus any time today on how to do the analysis of potential issues. I'm going to focus on the communications with the potential arbitrator. And of course, if you get it wrong, the consequences are serious. There's a potential challenge to the arbitrator, who may then hear that challenge, or the tribunal may, or the institution may hear the challenge, or perhaps a court, or the tribunal may decide to resign. And a resignation is not an acknowledgement that there was an actual conflict of interest. And the most dire consequence of failing to follow these procedures is having the award set aside at some future date. So again, my next session in December will talk about the actual analysis of whether conflicts need to be disclosed. So the first step in determining what information you want from your arbitrator appointee and how to communicate with that arbitrator appointee candidate is the due diligence part. So you need, every counsel appointing an arbitrator will want to do some kind of due diligence. And it's surprising in the Toronto market how little of that is actually done. It's often word of mouth. Emails go around firms. Who do you recommend as an arbitrator for this particular issue? And sometimes there are searches done of what the person's written, or a look at their CV and profile and all that kind of stuff. And that may give many counsel sufficient information and comfort to recommend an appointment for an arbitrator. But it's not uncommon certainly in international arbitration and in other parts of the world, where there's a lot more due diligence and investigation made about arbitrators. And the appropriate time to do it, obviously, is before the arbitrator is appointed. And the significance of making those due diligence efforts is huge. If there is an issue that gives rise to a potential challenge, that is one that counsel or a party knew or ought to have known in advance and did not make the proper inquiries, that party may end up facing an argument that it has waived any objection. So it's really important to make reasonable efforts to find out whether there are any potential issues that could give rise to a challenge. How it's done, as I've said, it's often quite informal, particularly in the Toronto market, but in some areas of practice, it is very common to do pre-appointment interviews. And one of the reasons why I thought this session would be useful is because they're rarely done in the Toronto market, and a lot of counsel don't know how to do them and have never had the experience of participating in one. So here's the how-to. And the importance of making sure that you do this properly cannot be overemphasized. The process is designed to ensure that it is regimented, it is structured, it is focused, and it avoids the kind of impromptu or casual conversations that can lead to potential objections later down the road. And the most significant resource that I'm going to refer to is the Chartered Institute of Arbitrators, Guidelines on Interviews for Prospective Arbitrators. And I will circulate that at the end of this session. But it is very helpful. It's obviously not a binding document, but it provides best practices, recommendations on the kind of interview that you may want to have in order to ensure that your arbitrator appointee has the skill set that you would like for your particular matter. And of course, the process depends upon whether you are looking for a sole arbitrator or to appoint one member of a 3-person tribunal. And the guidelines address both of those situations. So the first contact before you set up an interview is a critical one. And in my view, email is the safest way to contact a potential candidate. It leaves a record which can then be relied upon either to refresh the memory of the counsel or the arbitrator later on. It is much more formal, and it's easier to stay within the boundaries of appropriate conduct. And I often get emails from one party asking about my availability and my expertise, and that kind of contact is very common. Ideally, you would speak with your co-counsel and approach an arbitrator directly, but often that doesn't happen. And a single contact asking about availability and expertise, etc., should not be an issue. But again, be mindful about the parameters of the kind of contact that you have. So if I get a call and I'm asked to be considered for an arbitrator role, I want certain information and I want to provide certain information to counsel. So what do I ask for? I have a list of things that I ask for, and you can find it actually on my Arbitration Matters website. I've got under the tab Appoint Me, I've got a whole list of information that I like counsel to send to me when they're considering me for an appointment. So the parties' full names, names of key affiliates, names of key representatives. This is particularly important when you're dealing with large entities as well. Names of counsel, both the firm and the individuals who are going to be counsel in the arbitration. And that's the information that I feed into my conflict search. And once I've had that conflict search and it becomes clear, I'm a lot more comfortable in having discussions with the counsel about the issues in the arbitration. The other thing I ask for is a copy of the arbitration agreement, because there's some important considerations about whether, conflicts notwithstanding, I'm the appropriate person to consider the appointment. So first of all, does it require the issuance of the award in a particular number of days? And that's critical. You want your arbitrator to know that up front, because you want to ensure that your arbitrator has time to proceed with the arbitration and complete it within the time agreed upon by the parties. Does it require an arbitrator with specific expertise? Is the arbitration international or domestic? Will it be conducted under institutional rules, or is it an ad hoc arbitration in which the arbitrator is going to have to make rulings on procedure, the appropriate procedure? What's the appointment process? Is it agreed upon the parties? Is it done under a particular institutional rules? Will a court application be required if the parties can't agree? That sort of thing. The timing for the hearing, again, this has to do with scheduling. The language of the arbitration, absolutely critical. Presumably you want your arbitrator to understand the language of the arbitration. The seat. It sounds like a lot of information, but this helps both counsel and the arbitrator to have a full understanding of the scope of what's involved. A brief summary of the dispute. Now, this is important, obviously, so that the arbitrator can understand the area of expertise that's required, and to make sure that he or she feels comfortable with that dispute, and also to get a sense of, the complexity and all that sort of thing. Whether there is a third-party funder involved, because that may give rise to a potential conflict if the arbitrator has an interest in or a relationship with a funder, and whether there is another arbitrator already appointed. So if the arbitrator is being considered for a party appointment and another arbitrator has already been consulted and appointed, that's a potential relationship that needs to be run through a conflict search and could give rise to an obligation to disclose. So that is a huge list of information, but it makes sure that when there's a call or an interview, or the arbitrator considers whether he or she is available, there's a full understanding of what the arbitration is going to entail. This communication obviously not only includes information that the arbitrator is requesting, but also the information the arbitrator is providing, that the information that the counsel are interested in knowing. They want to know the ability of the arbitrator to manage the process efficiently. Most parties choose arbitration because they hear that it is faster, that it's more efficient. Sometimes it costs less. If that's the case, they want to make sure that their arbitrator is focused on process management and expediting the proceeding as much as possible. So wants to know that that's the same mindset of the arbitrator. Whether the arbitrator has technical expertise, knowledge of the specific substantive area. It may be a construction dispute, for example, where highly specialized knowledge is essential. So counsel will want to know if the arbitrator has experience in construction matters and feels comfortable dealing with those kinds of disputes. And of course, availability, absolutely key. Busy arbitrators may have difficulty meeting the time deadlines that the parties want. If what they're looking for is a very fast, streamlined arbitration, and that's one of the reasons why they chose arbitration over the court process, they don't want to choose an arbitrator who doesn't have time for them until 2 years from now. So that kind of information is obviously critical. And while some of these issues seem obvious, unless you have kind of a checklist before you, they can easily get forgotten. So let's assume that there has been that kind of an information exchange by email, perhaps, and counsel and the parties want to know a little bit more, and that's when there's a discussion about whether an interview should take place. That can take place once this initial exchange of information has been made and the arbitrator has put through all of that information into a conflict search and has come back clear. Now, whether an interview takes place is obviously discretionary, and an arbitrator can choose whether or not to participate in one, although I dare say that if a party asks for an interview and an arbitrator declines it, that arbitrator is unlikely to be appointed. But the point of the matter is that this is a consensual process of all involved. The most fundamental rule when there is such an interview is that there must be no advocacy about the case, and most certainly an arbitrator should not venture an opinion or provide advice on any aspect of the arbitration or issues that could arise, nor should an arbitrator give answers to so-called hypothetical questions. That's a real danger zone, because you know what happens when questions are asked hypothetically. They end up turning up in the hearing somewhere. Sometimes it's necessary to actually explain to counsel the parameters of what can take place in an interview. So they're eager to have a meeting to satisfy themselves that an arbitrator is qualified and able to take on a matter, but they don't fully appreciate the parameters within which that discussion must be made. And I have in the past sent to counsel a copy of the Chartered Institute guidelines, but they're quite lengthy, and you can see how that might be off-putting. So let's go to the best practices then in the guidelines, which apply both in the domestic context and in the international context, although they were drafted specifically for the international arbitration context. And they are considered quite formal, and so you'll hear a lot of arbitrators say that they don't follow them to the letter, which is one of the reasons I suppose they're called guidelines. So I think the lesson to be learned is that these are guidelines to be considered, but you should exercise your good judgment, and the rigidity of them may not be suitable in every case. So the general principles that they set out: any ex parte communication with an arbitrator without more is not a ground on its own to challenge successfully the independence or impartiality of an arbitrator. So while there are ground rules, there must be more than a contact. If parties are looking for a sole arbitrator, the arbitrator should not agree to meet with a single counsel or a single party in the absence of the other, except in very limited circumstances. And those are where the other party is aware of the interview, chooses not to participate, and also doesn't object. And the alternative is where the interview is by one party with a potential party appointee, That information, that interview will obviously proceed in the absence of the other party, but it still must stay within the boundaries of the proper content. So one way to make sure that the parties don't stray into dangerous territory is to set out an agenda. And so it's very good practice for the arbitrator to actually send to counsel a list of the things that will be discussed during the meeting. First of all, where is it going to take place? It should take place in a neutral location. An office, for example. Should not be over a social, drinks, or lunch. This is a formal meeting. It's important that professionalism be maintained. Who will be present? The arbitrator will want to know every person who's going to be present, and those names are probably names that have already been run through the conflict search. How long should the meeting take? Generally, these interviews should take no more than 30 minutes. And the reason for that is the number of topics that are on the table for discussion is fairly limited. And so the risk of having a longer meeting is that you stray outside those topics and have just an informal discussion. The agenda should identify specifically the matters that are open for discussion. The experience of the arbitrator, the expertise of the arbitrator, the availability of the arbitrator, the fees to be charged by the arbitrator. And if you attended my last session, you'll find out that sometimes fees are determined by the institution, but if not, the arbitrator should be prepared to discuss fees at that meeting. The general approach to arbitrations. That means that if a party is looking specifically for an arbitrator who is very committed to case management, moving the arbitration along, streamlining the process, customizing the procedure for the dispute, that kind of information can be discussed at the meeting. And the standard terms of appointment, such things as cancellation fees and those sorts of things. Those are topics that can be discussed. Off limits. Apart from a general discussion of what the case is about, there shouldn't be a detailed discussion of the facts or the circumstances of the case or the positions of the parties, even if both parties are present. There should be no advocacy. There should be no discussion about the arbitrator's views on issues that may or may not arise in the arbitration. So no advice and no opinion should be given by the arbitrator. There's no duty on the part of the arbitrator to take notes of that interview. A previous iteration of the Chartered Institute guidelines suggested that the session be recorded so that everybody would have a record of what occurred. That's really not the practice and is considered to be unnecessary. However, there may be circumstances in which an arbitrator considers recording the session to be necessary, in which case he or she should only do it with the consent of the parties, obviously. But I find it important to take notes. I take notes of every meeting I go to because my memory is poor. And I find, and you probably find as well, when you're juggling a number of matters, you often can't remember something that happened 2 weeks ago. And so I find notes very important and critical to helping to refresh my memory, but not required. And there's no general duty to disclose that an interview has taken place. This is obviously in the context of the party appointment process. The other party does not need to be advised that there's been an interview. So those are the Chartered Institute guidelines, which I've said is quite detailed. I think they go about 15 pages and set out a roadmap. Less formal are the guidelines found in the IBA guidelines on party representation in international arbitration. And in particular, guidelines 7 and 8. And this is a much shorter set of guidelines. I think it's only a few paragraphs. And it really focuses on a situation in which parties are looking to hire a 3-person tribunal, but the principles are they are compatible with the Chartered Institute's principles, but they're less detailed, leaving more room for judgment. So what they say essentially is that there's no ex parte communication between counsel and an arbitrator who's already been appointed, or unless agreed to by the parties or subject to limited exceptions. Some ex parte exceptions are permitted. So as I've said, communications about the appointment of a party representative to a 3-person panel. However, those communications are limited to the topics that I've already referred to that are listed in the Chartered Institute guidelines: expertise, experience, ability to take on the case, availability, willingness, potential conflicts, etc. The one additional topic that may be discussed in an interview between a party and a potential party appointee is the possible names of chairs. So most arbitration agreements that call for, or institutional rules that call for tribunals of 3, require or provide for the parties to each appoint one arbitrator, and either the parties appoint the chair or the party appointees appoint the chair. And so to go back to these guidelines, the topic of an appropriate chair is one that can be discussed during an interview with a potential party appointee. And in the IBA guidelines, it also says that an interview of an arbitrator is explicitly permitted if a party refuses to participate in the arbitration, so long as it takes no objection. So it's very important as counsel to stay within the parameters of those topics. Likewise, it's important for arbitrators to make sure that that happens, because if there's a sense of discomfort, that you've already created an issue in your arbitration, and the arbitrator may either decide to terminate the interview, or the party may feel uncomfortable and decide that this is not a route to follow. So once the arbitrator has been appointed, or the tribunal has been appointed, then there are rules about the limitations on ex parte communications with the arbitrators. And this is no different than the kind of rules we have in our court system about communications with a judge. So none of this will be of any surprise. But it's important post appointment to know that if there was an interview, there's no general duty to disclose it later on in the party appointment context. However, disclosure may be necessary if there's later a challenge on the ground of the either lack of independence or impartiality of the arbitrator. It's possible that it will be necessary for the arbitrator to disclose the interview in order to deal with a court application, or to deal with a challenge to that arbitrator or to the institution. After the tribunal has been constituted, it is critical that there be no contact between the tribunal and one party and not the other, or between any member of the tribunal and even both of the parties. So the parties are required to communicate with the tribunal as a whole, unless either the parties' agreement or the rules provide for the chair to deal with some interlocutory or procedural matters. And that's very common, that the chair will have a different role than the 3-member tribunal, and that the chair will actually direct the process. If that's part of the rules or the agreement of the parties, that's satisfactory. If you think of yourself in a hearing room where you're surrounded by counsel, witnesses, the arbitrators, heading off to the kitchen to have a coffee break, you can see how sometimes these kinds of communications can happen, and counsel and arbitrators have to be absolutely vigilant that they don't, and likewise counsel should be recommending to their clients that they not initiate any of these communications. So how does the arbitrator protect the appointment or integrity of the arbitration? And I've already described how the arbitrator keeps very close control over what takes place in the interview, and post-interview managing those communications to make sure that there's no informal coffee or water cooler communications happening. But there are obligations of disclosure by both the parties and the arbitrator throughout the proceeding. So if there are issues that arise which compromise the process, or because there are issues relating to witnesses or experts who are newly retained and create new conflict issues, those are ones that need to be addressed immediately, even if they arise in the middle of the arbitration. Some people, some arbitrators will record a proceeding if it's taking place over Zoom, for example. It's not uncommon for parties arbitrating small matters to not want a transcript for obvious reasons. Those are that's very expensive, and if an arbitrator may feel comfortable, and the parties may feel comfortable recording the what takes place in the hearing room. And I think that's a very important way that our arbitrators can protect the integrity of the process. I think that covers it. I don't have any questions in the Q&A box. So if anybody has any, feel free to put them up on the screen. If not, let me tell you what's up for my next session. I'm doing another session on December the 7th at the same time, called Ethical Issues Part 2, Bias and Challenging the Arbitrator, Practical Strategies. I'm waiting for professionalism credits from the Law Society for that one. The topics will be details about the disclosure obligations, and how the analysis gets done about what needs to be disclosed and what needs to disclose. And it's really mostly all about the degree of closeness between the arbitrator and parties, counsel, witnesses, experts, that sort of thing. And that's the kind of analysis that is somewhat different than the usual conflict search that we do as lawyers when we're taking on matters as litigation counsel. And there are multiple codes of conduct which assist with that, and guidelines in the international context. So I'm going to be digging deep into that, because those guidelines and rules are often used when parties are challenging the impartiality and independence of an arbitrator. And so it's important to know those guidelines in order to apply them to the tests that I talked about: reasonable apprehension of bias or justifiable doubts as to the arbitrator's independence and impartiality, in order to make your case that the arbitrator has not demonstrated independence and impartiality, or on the other hand, defend the position, the argument that the arbitrator has crossed the line. So I've got two questions which have just come up. So first of all, where do we find the guidelines? So again, I'm going to send them to you after this session, but the Chartered Institute guidelines on interviewing are found on the Chartered Institute website, easy to find. The International Bar Association guides on party representation are found on the IBA website. So if you just type in those words, comes up very easily. But again, I'll send them to you in PDF form and you'll have them handy. Another question. I have a quite large network of colleagues in the construction industry and are on LinkedIn. How much should I disclose, and should I call my network on LinkedIn? Paul, that is a question that we will discuss at our next session in December, because what you're really asking for is what kind of contacts are problematic. And I'm going to go to the IBA guidelines on conflicts of interest in international arbitration, and that's where you can go today if you like. But I'm going to go through those in detail, because the fact that you have relationships on LinkedIn is probably not enough information in order to make a determination about whether that's an issue you need to disclose or not. What more? Are these people that you have lunch with? Have they come to your birthday party? Do you regularly see them at events? You know, those sorts of questions are ones you should be asking yourself when you make decisions about whether those kinds of contacts need to be disclosed. And I'm going to give you a heads up on what I'm going to tell you in December. There's no bright line. It's all a matter of judgment, and it's not uncommon for arbitrators to call one another and say, what do you think about this? What do you think about that? And I think the best answer to that is take a look at the guidelines, go with your gut, and that's going to be your best remedy. There are a lot more challenges being brought now than there were even, say, 5 months ago. So it is a really important topic and one you need to turn your mind to. Last question. For a 3-member tribunal, what are the limits for a party discussing with the appointee, the appointment of the chair? I think they're the same limits as when you're appointing any member of the tribunal. So what experience does this person have? What expertise? What's their approach for dealing with arbitrations? I think from a chair perspective, I think you're looking for perhaps a different skill set. You're looking for somebody who can maintain good relationships in the panel. Among the members of the tribunal, someone who's very organized, because it's often the tribunal chair who is setting up meetings, making sure that that deadlines are met, and as I said, deciding procedural questions and that sort of thing. So if the chair is the person who is dealing with the interlocutory issues, it's absolutely essential that that counsel have case management skills, because that's presumably what the parties are looking for. So that might be something that would be more important than, say, one of the party appointees. If you're looking for one of the appointees to have some technical experience, say you want an engineer, you want the chair of the tribunal to probably be a lawyer, because lawyers tend to have the expertise in running the process, but you may have tribunal members who have other areas of expertise. So that's the best answer I have to that question. It's now about 12:42 and I don't have any other questions. So thanks so much for joining me. I hope to see you on December 7th. You will get both a recording of this session and the resources that I've discussed, and you will get an invitation to our next session. Have a great day.